Good afternoon, everyone. Thank you for joining us for today's panel discussion on the No Surprises Act. Before we begin, I'd like to make sure everyone can hear me okay, so please just type the word yes into the chat box if you can hear me. Great. Each attendee is in listen-only mode to avoid having background noises that may distract you from listening to the presentation. We'll have a question and answer portion at the end of the presentation, and if you have any questions, please type them into the Q&A box. After the presentation is concluded, we'll answer any submitted written questions as well as a live Q&A session where you can ask your questions on the air. Simply use the hand raise tool to ask your question. Don't forget to join us in June as we host AMHCA's 2022 annual conference in Las Vegas, Nevada from June 22nd through the 24th. Our full schedule will be released very soon. More information regarding registration, sponsorship opportunities, and hotel accommodations can be found at www.amhca.org/conference. Without further ado, I'll now turn it over to our AMHCA Board President and Interim Executive Director and CEO.
Good evening, everyone. I am Dr. Beverly Smith, the President and Interim CEO ED of the American Mental Health Counselors Association. Thank you for joining our webinar today on No Surprises Act. We have awesome expert speakers today who are clinicians practitioners in the field, and they will share with you their perspective on the No Surprises Act. AMHCA's position on the No Surprises Act is encompassed in a letter that I signed on with other national presidents and organizations. We do support in the administrator's goal to facilitate transparency in healthcare costs. And so we've signed on a national letter with other organizations, such as the American Psychological Association, the American Psychiatric Association, and other national organizations. Again, we agree with the premise of no surprises in costs to our clients, to our patients, but we do have other concerns that we share as to the burden that it does place on practitioners and clinicians, particularly those who are in private practice. And so we will drop in the link, and Rebecca will provide for you in a follow-up email that letter so that you are aware and you have that information. And again, I want to thank you for joining us today. We will introduce to you our presenters for today. Dr. Aaron Norton. He is a licensed mental health counselor, a licensed marriage and family therapist. He's also AMHCA Southern Region Director. He's been with AMHCA for a long time. He is a great representative and has a wealth of knowledge. He's also the Florida Mental Health Counselor Association Chair of Government Relations Committee. And so we welcome Aaron as a speaker presenter for today. We also want to welcome and introduce to you Dr. Becky Beaton York out of Georgia. She's a licensed professional counselor, a national certified counselor, and a clinical professional counselor supervisor. She's a founder of the Knowledge Tree, and she's also the former ethics chair of both Licensed Professional Counselor of Georgia, as well as Georgia Psychological Association. Becky brings a wealth of information to you. As with Aaron, they have been doing their research on No Surprises Act and want to share with you their perspective on No Surprises Act. Keep in mind, as this continue to unfold in the months to come, there may be some things that change. There may be a different direction or a different perspective or explanation. So keep that in mind as well. And they will share with you information on how to contact them after this webinar for further information and for further assistance. Again, I want to thank Aaron, Dr. Aaron and Dr. Becky for joining us today and for presenting. They will share with you and answer questions that maybe you've had. Some of you may say, what is No Surprises Act? They will share that with you. Some will say, what is the faith estimate? They will share that with you as well. So there will be an opportunity for a Q&A, and there will also be an opportunity for you to reach out to the presenters as well. Again, thank you for coming and have a great day. I'll turn over now to Dr. Aaron Norton. Thank you, Aaron, our Southern Region Director of AMHCA.
Thank you and welcome everybody. So I'd love to start off by just giving a few basics about the No Surprises Act, and then we'll be pretty open and casual today and allow you to be able to ask the questions that you need to ask. The few things I'll share to kind of get us on the same page is maybe starting with the rationale for the No Surprises Act. The rationale is that essentially people sometimes get unexpected bills, medical bills. 20% of emergency department visits, for 20% of visits, consumers receive surprise medical bills due to receiving care from a provider who is out of network. And the same can be said for in-network non-emergency hospitalizations. I know for me, I had an outpatient surgery one time years ago, did it all through my insurance in-network, and then suddenly I get this big bill that I didn't expect later on, because little did I realize that somebody, I think it was like the anesthesiologist, who was on duty that day was out of network, but nobody told me that in advance. So this is the sort of situation that this bill is intended to target. I would argue, my own personal opinion, that therapists were not a part of this problem. You know, we've always been very good in our field, as we're ethically required to do so, about communicating with our clients about costs ahead of time. I have not heard there being any significant problems among counselors with surprise bills coming to clients. I don't think we're a part of the problem, but we've sort of been caught up in the dragnet about the approach to resolve the problem. So on September 30th, 2021, a second interim rule got established that created an independent dispute resolution process and requiring good faith estimates for uninsured or self-paying individuals. And then November 17th, a third interim rule is created. And then we didn't start to see the associations starting to educate providers until December. And as you can see from the timeline here, the kind of running joke is the No Surprises Act has sort of been a big surprise to us all, because it is an act that I think significantly changes, at least administratively, how many counselors will operate in their practice. And a lot of people, when they first read about this act, they think, oh, I already do that because I already tell my clients about how much their sessions cost. But if you read the nitty-gritty details of this federal code, it is highly unlikely that counselors have historically been doing exactly what this code requires. It is a very kind of micromanaged, nitpicky process in comparison to the usual informed process that we use with our clients. So what we're trying to do now is sort of catch people up to speed and give them some helpful information about how to implement this act, which became law on January 1st. You can see it wasn't until that same day, January 1st, that the American Counseling Association published an FAQ for private practitioners, because there was a lot of speculation that we saw of people saying, oh, this doesn't apply to private practitioners. And I disagree with that perspective, as well as really everybody who I've read provide any authoritative information about the act. When we look at the definition of providers in the code, it does not seem to exclude private practitioners in psychotherapy. So I would say we certainly are. In fact, that's why the ACA created an FAQ for private practitioners, so that private practitioners would know how to implement this law or have some tools for doing so. So what are the basics? One thing to keep in mind is that this bill, it's divided into different subparts, and different subparts apply to different entities. You might read a subpart that's about facilities, and you might look at the definition of facility in the code and say, well, that's not me in my solo practice. And you might be right about that. But when we look at other subparts like subpart G, we also see that we're talking about providers, not just providers at facilities, but providers. And to make a long story short, providers are essentially any licensed healthcare professional in the United States. And here is the definition for provider in the code. The basic requirement is that if you have a client who is out of network, and that client, so I'll start with this. If you have a client who contacts your office and schedules an appointment, then you have 1 business day to provide that client with a good faith estimate, provided that the appointment is at least 3 business days away. If the client's appointment is at least 10 business days away, then you have 3 business days to provide the client with a good faith estimate. That good faith estimate is supposed to be in writing. The code does say that you can provide that estimate verbally to a client, but essentially 1 line later it says, but you still have to create a written statement, even if they ask for you to explain it verbally to them and you choose to do so. You also have to ask a client when they contact your office whether they have insurance and whether they intend to use that insurance. What's strange about this is you might be a practitioner who doesn't even work with insurance, and it doesn't say that you're excluded from that requirement of asking them that question. If they tell you that they are uninsured, or they're going to be a private pay client, or let's say they're an out-of-network client, they have insurance, but you're not in network, then you have to provide a good faith estimate, unless their insurer is a government insurance like Medicaid, Medicare, Indian Health Services, TRICARE. That is an exception because there are already existing laws that essentially govern those plans that don't require the good faith estimate to be generalized to them. Now, this could change in the future. You may have to in the future provide a good faith estimate for clients who have commercial insurance, even if you are in network, which is strange, but we have read multiple times that that's sort of on the horizon for future rules, unless government entities decide to change their mind about this. That's the short version. You have to have a good faith notice that informs clients about their good faith estimate rights. It should be published in your lobby, and it should be on your website, searchable on your homepage if you have a website. And some people ask what a searchable on your homepage mean. That essentially means that, for me, it's literally a link that says good faith estimate, or notice of good faith estimate, and a person could click on it and then be redirected to a different page and read about the notice. So you have to have a notice that informs clients of their rights. And then second, you have to actually provide a good faith estimate if the client is private pay, out of network, or if they are uninsured. Those are the bare bones rules. And with that, I will certainly turn things over to questions, and also to Dr. Beaton York. You may have an additional perspective or some other information you want to add, or there might even be, as you brought up earlier, a point that we might disagree on, which is perfectly okay. That's why we have it.
I know there's so many people disagreeing with each other these days, Aaron. So, you know, we're all figuring it out. And thank you for including me on this. I appreciate it. Just so you all know, I am licensed as a counselor, and I'm also licensed as a psychologist. So, and I teach a lot of ethics workshops. So I've actually been doing a lot of research from everybody's ethical perspective, you know, the social workers, as well as the marriage and family therapists, which I know Aaron's one of those as well. So I think one of the things I would love to jump in with really quickly is talk about the ethical side of it. So just so you know, if you need to contact me, I know we're going to have this up here available for you guys all later, but this is just some information on how to contact me. I know you're going to get the recording. I'm going to hop over to the ethics piece of it, because I think it's going to be really helpful in talking about some of the major questions you all have. So these are the core ethical principles that all of our associations roughly cover, and definitely AMHCA's as well. And so in terms of doing no harm, I think it's important that we realize that we don't want to hurt our clients with this. And I agree absolutely with Aaron in that this does seem like we have been caught up into this law that doesn't really apply to us, because we already in our informed consent, we make sure that clients do know ahead of time what we charge and what our fees are for various services. I will say I've been supervising counselors as well as psychologists for a long time, and money is something that they don't always like to talk about. So this does give us an opportunity to be a little bit more transparent, maybe letting people know that you do charge for phone sessions or answering emails, things of that nature. But from an ethical perspective, is one of the questions I'm getting a lot is, do we really have to give them a 12-month estimate. And really the way the law is written is no more than 12 months. So do we really need to give them that estimate? And that's the piece that Erin and I might disagree with slightly. And I will tell you, so many associations disagree with. And it may turn out that in the end, you do need to give them an estimate. But right now, I've been going off of what the trust, which is my malpractice carrier, states, as well as some other associations and some other scholars. So, because I feel really strongly about it ethically, and it could come back where I have to really, eat crow about this, but I do feel like giving people a year's worth of costs related to weekly sessions can harm our clients. So one of our major medical ethical principles is do no harm. And I've already heard about it from some of my consultees and other colleagues that people are saying, if that's how much therapy costs per year, I just can't afford it. I really can't take that out of my yearly budget. And people have already dropped off and decided not to continue pursuing therapy, which to me is just tragic. I also think that clients have a right to decide how long they want to be in therapy. And that piece really is reflected in our principle of respecting autonomy, that they have the right to choose, unless they're mandated by a court, to determine how long they want to continue treatment, how often they want to continue treatment, et cetera. So that's a really key piece. I've seen a lot of different templates out there where just do the first 4 sessions, the first 8 sessions, 12 sessions. I mean, even APA says, my typical sessions are 12 to 15. I don't know about you all, but I don't have typical sessions. It really depends upon what the client is presenting with and what their goals for treatment may be. So, and then it may also, when it comes to benefiting others, which is one of our other core principles, is that we need to make sure that clients don't feel badly about not meeting the goal. So what if it takes them longer than 12 sessions? Or, it takes them a lot longer than 12 sessions, or whatever you come up with initially. And we want clients to feel good about their investment in therapy, not necessarily overwhelmed by the cost. So additionally, the being just piece will come in later. This, I believe today, Erin and I are just going to be talking about the part that's rolling out now with the No Surprises Act, where this is just for self-pay people at the moment. It's not for people that are taking insurance, clinicians taking insurance, or clients wanting to use their insurance with somebody in network. It's just for folks who are paying out of pocket, don't have insurance. And there is a lot of debate about whether or not it should be included for people that are turning in their own super bills to get reimbursed. And according to the trust statement that they put out, that we should go ahead and give it to those folks as well at this point, but that could change. So, but long term, there's a lot of talk about the fact that the insurance companies may dictate what we can charge out of network. And when that comes into play, we really want, the associations to really lobby for us. And I know that AMHCA will take an active role in that, so that we don't have that dictation coming from insurance companies. But so here's just some other pieces about according dignity, which also fits in with how long it's going to take them to actually be in therapy, that we want them to feel, positive about that. Some of these templates, there's really basically 2 templates that come from HHS/CMS, and some of their wording is a bit harsh. And so, and choosing to go out of network shouldn't be shamed for people. It should be, sometimes that can really help them get better more quickly. So, so we really want to, not discourage them. And some of the forms can be looked at as discourage them for using out-of-network providers. And then also us just accepting our own accountability for making sure that we are talking about our fees, being transparent about that, and considering all the possibilities going forward, because it really falls upon us to actually take the lead in talking about these issues. And so, so I know that we have lots of questions already jumping into the chat, and I just wanted to give my little quick ethics speech. And so, Aaron, you want to come back on, and we can have our dialogue here.
For sure. Yeah, I'd love to start by saying I'm actually very happy to say that I don't think there's a single thing that you said that I disagree with. So
Oh, good.
I
Okay.
definitely did not intend to imply that you must include 12 months of services in
Oh, good.
your good faith estimate. I absolutely don't think that's the case. You are absolutely correct that it can be a maximum of 12 months. You can't do a 13 or 14 month out. And I think part of maybe the confusion is that in my practice, the nature of my practice is such that my clients that I work with out of network are perfectly okay with seeing a good faith estimate that has 12 months there, which I tend to do in a scenario where I'm like, I don't know how long this is going to go on for, but we may be seeing each other weekly for the entire year. And I'd rather overestimate than underestimate, because if we end up doing more than what I've estimated, then there's the potential for the client to then initiate a disputation. And if the discrepancy between what's in my good faith estimate and what we actually do is greater than $400, there's a good chance that they're going to win if they were to use the dispute resolution process. And then I might have to refund money. So I kind of prefer to overestimate than underestimate. And also, I don't want to be doing good faith estimates every week for various clients and things like that. So in my setting, it kind of works out well. If I had a client though, and I know I'm not going to be working with them for more than a few months or something like that, then I'm going to do a good faith estimate that would look more like that. And then if for some strange reason we end up going longer than that, then I would have to do a second good faith estimate.
Mm-hmm.
And the way that we do this, I know some people have asked already, well, first of all, what is this good faith estimate supposed to have on it? So I guess that would be a really good thing for us to show you all before we go any further, because some of you know that and some of you do not know that. So
Okay,
this
great.
is literally what subpart G says a good faith estimate must include: a patient name and date of birth, a description of the service, an itemized list of those services, the applicable diagnosis codes, expected service codes, and expected charges associated with each service, the name, NPI number, and tax ID number for each provider or facility providing the service. And then there are 3 different legal disclaimers that must be included on that good faith estimate. Now, the federal government has provided us with a template. That template I'm not a big fan of for a lot of reasons. And one of them is for your average counselor in an independent private practice. A couple pages of that are not going to be used anyway, because they apply to more complex situations that you might see in hospitals or surgical centers where you might have multiple providers working with the same client. That's not going to be the case for most therapists. Instead, I have a very simplified 1-page form that just has the bare bones of what the law requires. And there is a difference between law and ethics. It's nice when the 2 overlap, but unfortunately they sometimes don't. So take a look at this one, applicable diagnosis codes. Well, remember, I showed you the time frames earlier. A client calls your office, they schedule an appointment. You have to give them a good faith estimate within a business day if their appointment is between 3 and 10 business days away. So how do you give a diagnosis code on a form for a client you've never met? That's not ethical. Why would you diagnose someone that you've never even met with? I would argue that our ethical codes would certainly, at the least, highly discourage us from doing that. I would argue it's just inappropriate to apply a diagnosis code to a client you've never even met with. So for that reason, in our practice, what we do is we have an initial good faith estimate that we give to clients when they schedule their first appointment. This good faith estimate has the CPT code for the initial appointment, 90791. It has the charge, and then it has a diagnosis code, and that code is the code that means no diagnosis. It's an ICD-10 code that refers to no diagnosis, and I might show you an example of that in a moment here. Because ethically, I'm not going to diagnose a client I've never met with. And then after meeting with the client for the initial appointment, we issue a second good faith estimate. That good faith estimate is going to have the therapy appointments outlined in it, and that will have a different diagnosis code. It might be a provisional diagnosis, but it's going to be a different diagnosis code than the one for the initial appointment when we haven't even met with them yet. So at minimum, we're doing two, in my practice anyway, the minimum is that we're doing 2 good faith estimates for each client that for whom we are required to issue a good faith estimate. So is there anything that you'd like to add to that, Dr. Beaton-York?
I would love to. If you don't mind, I'll share my screen for a second. Okay, cool. So this is where Erin and I are in agreement, but we have a slightly different approach to this. So what I do in my practice, and that what I suggest is, so I'm coming again, I'm also a psychologist, and so I am going off of what the trust says, who's my malpractice carrier, and they tend to cater to psychologists. The trust says that we can make a general statement on the form and that we should take the CMS form, but I agree with Erin, it's awful. I'm not a really big fan, but the trust says, I think it's really more for physicians. The trust says that we should just go with their form, because they say we should, that we need to make a good faith effort. And that doesn't mean it has to be perfect at this stage. APA's also come out, as well as just about everybody has come out and said that, the chances of us getting in trouble right off the bat is pretty slim, but we still need to do our best to comply. So the position that I come from is that if they're a brand new client and you do not know their code, of course, we do not want to give them a diagnosis. So either to put TBD, which it sounds like Erin is in agreement with, or to put Z65.9. And if you remember when the new good faith estimate, the new DSM came out, the V codes turned into Z codes, and the Z code is really very open, and it basically means problem related to unspecified psychosocial circumstances. So if you don't want to have to redo the form again, and maybe you don't even like to give diagnoses, then you can just give that Z65.9. And then you make some kind of a general statement about, we will decide about this together. Again, this is the CMS form, the template that's out there for us. And what the strategy I come from is the ethical, to me, is just taking the ethical lead, which, and it may come back later that I have to put dollar amounts, and the trust is in support of this, is to put, your therapist will collaborate with you throughout your treatment to determine how many sessions and/or services you may need to receive the greatest benefits based on your diagnoses. And then, or presenting clinical concerns, and you just leave it open. And then what I've done, since according to the trust, we're not supposed to alter this form at all at this stage in the game, but I know lots of people have, so no problem there. Is what I've just done is a C attached, C attached, C attached, and then came up with a CPT grid / table that talks about your regular hourly fee, the various things that services you may provide, and then just put it all up front, so that if you end up charging, I know somebody asked in the chat, what if you have an emergency session that comes up and you're going to charge lump more? If you've given them an overall blanket statement for everything you do charge for, including a crisis, then you have everything out on the table ahead of time, and you don't have to worry about redoing another form. So I just know me, and I know some of the folks that I consult, and the chances of everybody getting those new forms out, or you decide to add something new, is it's a lot of paperwork. So, and I also really encourage people to charge for their phone time, for their email time, to charge for cancellations. I've just known so many great therapists that have burned out way too early from people wanting a lot of services that they didn't charge for. And I know it's well-meaning, but that it does cause burnout quite a bit of the time. when we don't charge for our services. So that's the one way we can make lemonade out of these lemons, is really trying to find ways to actually charge for the things that we do. So Aaron, you want to pop back on? And I know we've got some questions coming in. And
Sure.
did you see any questions while I was talking that you want to address?
Oh yeah, there are a few of them. And I'll just also throw in very quickly here, and you certainly can let me know if any of this sounds wrong to you, but the code doesn't technically say that we have to use the form that the government has provided us with.
I agree. It's
Um,
just the trust that says that. So
yes, it
I
could
think
very
they're
well
trying to
be
cover
though.
themselves.
Yes, I could see a malpractice insurance company saying, well, we recommend that you use that form because that way they don't have to worry about a provider creating their own form, but leaving something out that's required under the law. But I would also say that if you take the law line by line and you ensure that everything in there is in your form, then I think it would be an option to use it. I'll project as an example the one that I use in my practice for an initial appointment. So you can see how simplified it is for a practice like mine. Now, the codes, there are different opinions about what to put in the diagnosis code for the first appointment, and they all sound right to me. Like, I think it's okay to say TBD. I think it's okay to use the other psychosocial circumstances code. I prefer Z03.89 because that is the code that the APA agreed on as no diagnosis yet for the DSM-5. But we in December decided to use this code. And interestingly, January 1st, when the ACA released their FAQ page, they recommended the same code for the initial appointment. So that was kind of interesting. You can see I've got the patient's name, their preferred communication, their date of birth, the date of that initial appointment, the CPT code, the description of that code, the diagnosis, which means no diagnosis yet, the quantity and the cost of that appointment. These are our providers, their names, their MPI numbers, their taxpayer ID numbers, the location that the service will be provided, and the 3 disclaimers required by law, all on one page. My practice is fairly simple. So there are only a few CPT codes that I use. So my second form has those CPT codes listed on it. And I kind of know, am I doing family therapy or am I doing individual therapy? I do also do evaluations. So for those, I have an entirely different GFE. But for my typical therapy client, it's pretty simplified. And I think this is one way to not have that big, scary, 4-page long or whatever federal form, most of which doesn't seem to apply to the kind of practice that we have with our clients. As far as questions go, there are a bunch of them that people have been throwing into the chat box here. So I'm going to try and maybe take them one by one. And first of all, slides. I will gladly paste into the chat box in a few minutes a link that you can use to access my slides and handouts, including I have a list of all the different links to all the different organizations that have put out some helpful resources on complying with this act, like the ACA, AMHCA, APA, NBCC, et cetera. And the Trust Parma article written for private practitioners. And then Salma pointed out, the concern about diagnosis, and I certainly agree with that. This is where we get into an ethical issue also. Let's say that you do know the diagnosis for a client, but you're concerned about the diagnosis being communicated to the client. I know there is debate about that sometimes. The Code of Ethics talks about there being scenarios sometimes when a counselor may decide not to share a diagnosis with a client. In my practice, I don't really have to contend with that. But I know that some of you may be in a different scenario. For me, diagnoses are always out in the open with my clients, and I don't really run into problems with clients being aware of their diagnosis and it becoming a part of the work that we do for them to have knowledge and information about that diagnosis or those diagnoses. But there could be scenarios where somebody will experience an ethical dilemma. Do I put this diagnosis code on this form, which the client then gets? So I guess I would say for many clients, there's more than one diagnosis. And also remember that there's this giant chapter in section 2 of the DSM-5 called Other Conditions That May Be a Focus of Clinical Attention, which you were referring to earlier, Dr. Beaton York, and that section is what we fondly refer to as Z codes, even though technically they're not all Z codes. And that includes lots of diagnoses that are not disorders, but there's circumstances and stressors that you might be working with a client on. That might partly answer the question that somebody has about, could it ethically not be a good idea to put a diagnosis on a good faith estimate in some cases. Somebody's asked, did you say it's just for private practice? No, it is not. But the thing is, if you're a counselor working in an agency, then probably it's not your job to figure out how to implement this law. That's probably your administrative people who are working on this, hopefully. And you as a clinician are probably not as involved in figuring out how to implement the No Surprises Act in an agency setting. But it does apply to agencies and healthcare facilities. Somebody's asked, so do we have to give an estimate to a Medicare recipient or a TRICARE person? So literally on the CMS website, it says that this good faith estimate requirement does not apply to, and then it lists Medicare, Medicaid, TRICARE, and Indian Health Services. I think there's some other kind of government funding source that they listed as well. But that's what it says on their website. So I would interpret that to mean, no, you wouldn't have to give this to such a client. Let's see here. How do you give a diagnosis code if you haven't had a chance to complete an assessment yet? I think we've covered that pretty thoroughly.
I think we've covered that, yeah. Mm-hmm.
And so 2 GFEs, oh, go ahead.
No, you go ahead, you go ahead.
So another question was, so 2 GFEs for new clients, I presume? And again, what I would say is, in our practice, we do, you can decide how to do it in your practice, but in our practice, we do 1 GFE for the initial appointment only with the code that means no diagnosis yet. And then after the counselor has met with the client and conducted an assessment, then we would do a second GFE after that second appointment that that looks forward into the future in terms of what we may be providing in terms of therapy. And we have a clause on our GFE form that says, you know, of course, that this could change. Like, even if we have a recurring appointment client, a client that they're meeting with us once every week for we don't really know how long, we still say, depending on your progress and on our mutual, you know, agreement and that sort of thing, here's what we're thinking could be happening. So all of this is tentative. Nobody expects you to have a crystal ball, but just remember that if you underestimate and then you don't issue a new GFE when you're going over what your original estimate, then you are now subjecting yourself to the potential for the independent dispute resolution process and for a client to then essentially petition to get a refund for especially if the discrepancy is more than $400.
So I'm going to hop in really quickly. If you're finished with that statement, okay, I'll hop in and answer a couple questions. One person asked about how to do this with an EHR platform, an electronic health records platform. How do you get your clients to sign these? So I tell you what folks that I've been consulting with have said that they're doing is they are, and maybe Erin wants to pipe in too, is that, so, and I want to clarify that there are 2 forms. It seems like just looking through the questions, there's a little confusion about this. There are 2 forms. I know Erin said this, but it's worth repeating, apparently. There's a notice that needs to go on your website, and that notice is basically very general, and it says what the No Surprises Act is about and what your rights are. And that's supposed to go on your website and or someplace prominent in your office. If you have either of those, I know some people don't have either an office or a website these days. And if you have neither, then you're supposed to email it to a client securely, ideally. And you're supposed to email it to them just so they get access to it. And then the other document is the good faith estimate. And that's for each client that you are giving a good faith estimate to. And And so some people may have a sliding scale, maybe clients are paying different rates. That's why it needs to go individually to each client. Now, unless you have a set rate for everybody in your practice, then it could be just part of your documents in your portfolio that you give, your intake paperwork. But you do need to make it a separate document no matter what. It can't just be your informed consent. Again, worth repeating. And so with in electronic health records, I've seen what a lot of folks are doing is they create the good faith estimate and they leave it blank where the client's name is, and they leave it blank where the birth date is. And then they have added a signature line, even though the document they're saying that we're supposed to use, or the template that's on the CMS HHS website, doesn't have a signature line. Everybody's really encouraging us to really cover ourselves by getting a signature, or at a minimum documenting that you have given that client a good faith estimate. So what people with AHR systems are doing is they're having the client fill in their own name, they're having the client fill in their own birth date, and then unless you already have a diagnosis and you've been working with them and giving them one, then you do one of these strategies that Erin and I are talking about, whatever you want to put in that diagnosis section, but you have it all ready to go so they don't have to diagnose themselves. And then they sign it in an EHR platform that is an authorized electronic signature, not one where they just type in their name, but one where you can document that they signed it at a particular time and date. And then they upload it into your portal. So hopefully that answers that question. Erin, did you see one you want to answer?
Yes, I've got a few of them here. First of all, I did, people have asked, well, Erin, how do I get your slides and templates and things like that? So I just pasted a link to that information. And we did it for the Florida Mental Health Counselors Association, a webinar where we really walked through, what a good faith estimate is supposed to have, and some practices and guidelines, and the notice that you're supposed to put in your lobby or on your website, and all of those things, so you can access that and then review that information later on. We have the question, let's see if I can find, I just lost it, sorry. What about existing self-pay clients? That's an important one. So some people are like, oh, okay, so starting January 1st for new clients, I have to do this, right? No, you actually have to do it for your existing clients as well. Mm-hmm. So if you were already seeing a client before January 1st, you're still supposed to complete a good faith estimate. If, again, that client is self-pay, private pay, out of network, and non-government health insurance funded, then you would still need to do a good faith estimate. Let's see here. Erin mentioned disputation and potential refunds being issued. Is that the primary enforcement mechanism? So there are fines up to $10,000 for a violation. However, in the interim final rule that was passed, you can actually read for yourself this very interesting and kind of confusing looking statement, certainly overly wordy statement, where they essentially say, we recognize that it is highly unlikely that providers will be ready for this on January 1st, and that it will take time for them to become ready. I'm paraphrasing, by the way. But, so, we're going to use judgment and enforcing things for a while. And then like a couple sentences later, it says, nonetheless, do this now. So it's like one hand giveth and the other taketh away.
There's so many examples like that. It's kind of ridiculous. Mm-hmm.
Yeah, it's sort of like the same thing that happened when the pandemic hit, and CMS said, we might kind of look the other way on not using a HIPAA related or a HIPAA compliant platform for telehealth for a while. But by the way, get a HIPAA compliant platform. So it's sort of like that. I can't tell you what it's going to look like. So fines can happen for not enforcing the law. I think we're unlikely to see that in the near future. And then the second potential mechanism point is that a client can initiate a complaint through the independent dispute resolution process if what you actually end up charging them is greater than what you included in your good faith estimates. So I would say those are like two different enforcement mechanisms. I'm not aware of any other ones.
I'll jump in there for a second. I do know that that the states, many states actually out there, and I know you guys are from all over the country. I've seen that when you were checking in, that a lot of states already have fee transparency laws in place, but many do not. And they may not comply exactly the way this federal law does. So until the states actually weigh in with the federal law, then for now you do need to use use another form that's all encompassing, but do be on the lookout for your state to see if they come up with something different. Also, but it will need to be more stringent than this one to actually trump this particular version of the federal law. And they say that the states will be the ones ultimately to enforce the law, that our licensing organization, wherever that may be in your state, like for us here in Georgia, it's the Secretary of State. I don't know what it is for you, Aaron, but whoever governs your license will be the one that will initiate the fine. From what my reading. Do you have a different take on that, Aaron?
I do not. You probably know more about that than I do. I just kind of saw in some articles up to $10,000 fines,
Yes,
and then stopped there and didn't go any further in looking into it. So I don't really know how fines would happen or be initiated. Not sure about
I
that.
think I just want to really enforce that the main thing we need to be doing right now is a good faith effort for our good faith estimates. So we're all going to be making mistakes at this point because there's so much conflicting information. So just do the best you can. And I know some of you haven't done anything, even though it went into effect January 1st. And yet it really is a good idea to do something. They say that if there was something to come down, like a client was to turn in a complaint that your charges were greater than, they were more than $400 in excess of what you told them that you were going to charge, if they were to initiate that, and you did make a good faith effort, you're less likely to get in trouble, if you will, however that's going to happen at this point, if you at least made an effort. So I know there's a lot of wait and see going on out there, and I can understand that. But I do think we're kind of getting to the point where we do have at least a good faith effort strategy. So it's a good idea to take one of those strategies.
Absolutely. And I'll say some people have asked as far as like getting the GFEs signed and things. I use Therapy Notes as my electronic health records and practice management system. And so what we do is we upload the form into their portal, and the system tracks that you gave it to them and the client received a notification that it was available to them. And then it also tracks whether the client accesses it or not. We've kind of taken the position of we tell the client about it verbally, we provide it, we document that we provided it, whether they want to access it or not is kind of up to them. That may not be the practice that your malpractice insurance company recommends. They may like that you actually have them sign it to acknowledge that they got it. Maybe that is the gold standard, so to speak. And our system does allow us to require a client signature on it. Whether the client signs it or not is another question, especially when you're doing telehealth and they're not physically in the office and you can't be like, here, sign this. But so we've also had questions about, do I need to give this, if I'm submitting claims for them and they're out of network, then do I still have to do a GFE? There's nowhere in the regs that I can see where it says, oh, by the way, if you're submitting claims for them, you don't need to do one. So I would say, yeah, you still need to, if the client is paying you and they're out of network, then you'd probably still need to do a GFE. I don't know what do you think about that, Dr. Beaton-York?
I'm with you on that. That's good. I'm also noticing a lot of questions. And just so you know, anytime Aaron's talking, if you see me up here, I'm actually answering a lot of these in written form in the Q&A, just to try to knock them out. So maybe Rebecca can make the Q&A available for people later to see some of my written answers. I don't know if you've done that at all, Aaron, but you might get some answers to some of those questions. Maybe Rebecca can do that. But one of the questions that I've been seeing a lot is, If this is further on down the road, so I kind of want to help just you guys calm your nerves a little bit right now, is that people are saying, do I have to deal directly with the insurance carriers? Do I have to give them this? If somebody wants to file out of network, do I have to do that for them? Because the law has stated some of that. And I will let you know that there are several associations that are lobbying to change that, because I already know one consultee of mine who, she actually had an insurance company tell a client what her rates were, even though she wasn't on any panel, because other people had filed out of network. They had filed out of network benefits to be reimbursed, to, you know what I'm saying, they claim their adequate network benefits. But the insurance company actually had it on file and told the client, you know, what if the clinician had changed their fees since the last time a client had done that? So it's, you know, there's a lot of the insurance companies getting into our business, and many of us have gotten off panels because we don't want insurance companies getting into our business. So I know you guys are worried about that and what you need to do for people filing out of network. I will say that there are a lot of folks fighting that, and the piece about what's going to happen for in-network clients using in-network benefits, as well as these folks filing for out-of-network, that is really probably not going to roll out until 2023. So we have several months to argue with people about that. So don't worry so much. And then there's been a few people asking about pro bono clients. Do I need to give them a good faith estimate? And actually, the advice I've read is, yeah, just give them one and let them know what your normal fees are, but they don't have to be paying that. And so
then somebody should disregard the answer I just typed, because I said, if there's no fee to disclose, I don't really see why I would be required to do a GFE for a pro bono client. But,
well, two different opinions, right? I mean, the trust says that you should, just so that you actually document that you're not charging them.
Okay.
So again,
that sounds like a very valid perspective to me.
Yeah. And I think you've already answered the piece about long-term clients you've already had. You definitely need to give it to folks that are already on your caseload. And if the diagnosis changes, do you need to change the GFE? I'd love to hear your answer on this one, because I've heard it go both ways. But you know, some people just leave the diagnosis and that's that. But I think technically you really should. So what do you have to say about that, Aaron?
Yeah, I would say that, you know, I'm not an attorney, but I would say if we were looking at this from a legal perspective, you wouldn't have to, because remember, the good faith estimate is at this point, here's what I anticipate, right? So there's nothing in the code that says, oh, by the way, if the diagnosis changes, you have to reissue the good faith estimate. It is an estimate, a good faith estimate up front.
Yeah.
It may end up being that the diagnosis changes. That's okay. Now, could it be a good practice to issue a new one? Maybe. I think somebody can make a good argument for that. But I wouldn't interpret, you know, my reading of the law wouldn't suggest to me like I would have to, where I could get in trouble or something along those lines.
I agree with you on that too. Exactly. That's why I like the 65.9 or yours, where you're not giving a diagnosis, you know, so you just kind of leave it there for a minute. And do you see another question?
Somebody asked if this applies to coaching versus therapy clients. That is a question I've heard from people before. My belief is, if you're not providing healthcare, then how could this law apply to you? So if you're a coach, number one, if you're a coach and you're not a licensed healthcare professional, you're not part of this law anyway. Second, if you are a licensed healthcare professional, but maybe part of what you do is coaching, then I think that's where things could get a little bit sticky. The codes that we're talking about are therapy codes meant to diagnose and treat disorders. And if you have a coaching client and you're not providing psychotherapy, I would think you can make a good argument that these laws would not apply to that client. But maybe the mere fact that you're attaching your license to that branch of your practice where you're offering coaching, and if we look at your website and things like that, if this is
that's a good point.
then maybe one could say you really ought to do a GFE anyway, because you're using your license to promote your work. You're implying that this is therapeutic work with somebody. So I don't really know if there's a clear right or wrong on that one. I'm a little mixed on it myself. But I do know if you're if not just a coach, but if you're a coach and you're not a licensed healthcare professional, I don't see how this law would apply to you.
Exactly. I know I've heard a few therapists saying it makes me want to just go be a coach. But we're not advocating for that by any means. You guys worked really long and hard to get your license. We want you to keep it.
Yeah, absolutely.
This is another one I would love your opinion on, Erin, is, the NPI number is, it's on the CMS form, the template, the NPI number. And I'm advocating for putting an NPI number just because it's on their original form. But I've heard some conflicting things about that. What is your take on that?
So let me go to what it actually says in the regs themselves. It says the name, national provider identifier, and tax identification number of each provider or facility represented in the good faith estimate. It doesn't say that it's optional. It's listed under must include. So it appears to be required. Now, some people have asked me a very challenging question. Some people are solo proprietors tax-wise, where they literally use their social security number to bill their services, and they have no federal tax ID separate from their social security number. In such a case, it is extremely understandable to me that somebody would not want to put their tax ID number on a good faith estimate that goes to a client. All I can tell you is it lists tax identification number as a requirement in the code. It doesn't say, unless, by the way, your tax ID number is your social security number. And this creates quite a quandary and perhaps is an example of a flaw in this code. Because I don't think they were thinking about that there are people out there that they do a little bit of private practice on the side. They don't have an LLC or something like that, and they're using their social security number as their tax ID number. So I don't really have a good answer for what to do in that case, except that I could see myself trying to get a tax ID number separate from my social security number if I were in that boat. Do you have an opinion about that?
I actually really encourage therapists in general to go get a tax ID number, even if you're a sole proprietor. It's really easy to do. It takes about 5 minutes. I've done it for friends when I was over visiting and they're like, how do I get one? I'm like, let's go do it right now. Take us 5 minutes. So I just think get your social security number out of the equation, because if you ever give a super bill, you want to make sure that you don't have that social on there. And super bills are supposed to have some kind of tax ID on there. But I agree with you. If you haven't done that yet, don't be giving them out. I've had identity theft before, and we don't want to encourage that. So I think we're on the same page. And I realize it's 2:00. So hopefully we've answered a lot of your questions. Again, we'll try to get Beverly to save the Q&A for us so that the ones we've done in writing for you, we've handled. I have an hour course on this. That looks like Erin has one too, and another course on it. So if you want more details, I'm sure the American Mental Health Counselors Association will continue to come up with updates for you all. And hopefully this has been helpful. Any closing remarks for you, Erin?
Yeah, I just want to say I would like to highlight something that you all already put very well, which is it's time to make a good faith to do this good faith estimate thing, right? There will be new rules coming out. I feel very confident about that. We will probably be getting clarification on some things down the road. Some things will probably change for the better or for the worse. I also want to offer a perspective, although I was very frustrated about this, and I still am kind of frustrated about it. I just think it's so micromanagey and nitpicky, and it seems like it's for lack of better wording, a shotgun approach to a problem that required a scalpel instead. But that personal opinion aside, really all this is trying to do is to get us to do what we have ethically been doing all along in a more structured and specific way. But I think we can all be on board with the general principle, which is we don't want clients getting charged things that they were not appropriately informed that they would get charged for. So the spirit of the law, I can appreciate even if I don't like some of the nitpicky details. I think the important part for you is to create your templates, create your notice, get it out in the lobby, get it on your website, start doing your good faith estimates. You may learn along the way that there's something you might need to tweak or adjust, or practice that you may need to change, and that's okay. Then change it, but making that good faith effort is important right now. Doing nothing, would not recommend as the course of action at this time.
I agree. And thank you all so much for coming, and we hope this was helpful for you. Also, Will, I know Rebecca's going to send out ways to contact us. So if you have further questions, and thanks again.
Thank you all so much. Have a good one.
Thank you, everybody. Sorry, I was trying to copy over all the questions real quick because it doesn't actually save the questions. It'll save the chat, but it won't save the Q&A. So I was just trying to go through quickly to copy those over. I just wanted to say thank you again to Aaron and Becky, and thank you everyone for attending today's panel discussion on the No Surprises Act. Once you leave today's presentation, you'll receive a survey, and we would appreciate it if you would provide your feedback. Don't forget to look for your follow-up email within the next few days with a recording of today's event. Have a great afternoon.